Has a study proven that using an AR for home defense increases your chances of conviction and results in longer sentences? The answer is absolutely not. And in today's show, I'll explain why that claim is utter nonsense. And for those of you who stay to the end, I'll share with you how you can join us for our 100% free Law of Self-Defense Hard to Convict class coming up in just a few weeks. So a YouTube video was recently brought to my attention, and it has a rather provocative title: How an AR-15 Can Send You to Prison. It was produced by attorney James Reeves and was actually published about a year ago, but I just learned of it last week. The claim of the video is that a home defender who uses an AR platform rifle to defend his home against a threatening burglar is about 50% more likely to get convicted and is likely to get a several times longer prison sentence than would a homeowner who used a more traditional-looking but ballistically equivalent alternative such as a Mini 14. Importantly, this claim is purported to be supported by substantive research in the form of a psychology study involving a mock jury trial involving those and other alternative weapons. Is it true that the study cited by attorney Reeves can be relied upon as a model with predictive value to conclude that the use of an AR for home defense substantially increases the risks of a conviction and longer sentences than would the use of a Mini 14? The answer is absolutely not. And the reason is that the underlying study itself is a hot, steaming pile of cow dung that is entirely unrepresentative of how questions of conviction and sentencing would be answered in the real world. As computer programmers say, garbage in, garbage out. And this study is the garbage in to this question of conviction and sentencing, and therefore the findings of the study are the garbage out when it comes to any real-world relevance. Now, before I dive into the substance of why this is so, I want to make explicit upfront that none of this is intended as any kind of personal or professional criticism of attorney Reeves, who posted the original YouTube video. I don't know Reeves, but I have no reason to believe he's anything other than a smart and capable lawyer who's passing on his good faith understanding of the relevance of the study to the law-abiding community. What's apparent, however, is that either Reeves never read the original underlying study, relying instead on a kind of dumbed-down summary intended for a general audience, or that he lacks the training to critically evaluate the methodology of a purportedly scientific study, or both. And that's why he succumbs to the clickbait conclusion of this profoundly defective study. And that would be what I would expect from a lawyer. Few lawyers have any substantive training in good methodological practice. It's just not a thing that a typical lawyer would have training or experience in, so it's certainly not a knock on attorney Reeves that he would lack such training or experience. My own background in this area is uncommon for a small-town lawyer. I spent some years doing graduate work at Harvard in a wide variety of scientific subjects, including molecular biology, virology, immunology, epidemiology, and much else. And much of that study required the development of expertise in methodological design and critique. So that's the skill set, someone unusual for a lawyer, that I'm bringing to today's show. So with that background, let's dive in, starting with selected portions of attorney Reeves' video shared with all of you for purposes of fair use under Section 107 of the Copyright Act of 1976, meaning for the legally permitted purposes of criticism, comment, reporting, teaching, scholarship, and research. I will, of course, link to attorney Reeves' original YouTube video in the description of today's show, and I do urge you to check that out for yourself in its entirety. Now, attorney Reeves starts out his video acknowledging that his title, How an AR-15 Can Send You to Prison, is a bit clickbaity, but insisting that the underlying claim is in fact real.
Apologies in advance if this video has a super clickbaity title. It's just kind of hard to come up with a concise but accurate title for "Be careful which gun you use to blast a home intruder," because it could have negative implications at trial and sentencing.
Reeves then goes on to explain his default response to the commonly received question, does it really matter what gun or ammo I use for self-defense?
I give speeches and I hold free lawyer Q&A sessions a couple of times a month. One of the most popular questions I get asked every single time is, doesn't matter at trial what kind of gun I use in a self-defense incident or what accessories I have on that gun. For years, my answer's always been, unless it's something like really bad, like a surprise ejection port cover or a cringy Punisher skull set of grips or something, it really doesn't make a difference if you have a lawyer who can explain the advantage of using an AR-15 instead of a double-barreled shotgun for home defense.
And by the way, that is also my own default response to that same general question, and I certainly don't plan to change my default response based on this silly study. Now, Reeves doesn't feel the study is silly himself, however. He refers to it as substantive research.
There's substantial research out there about this exact subject, and what it points to is actually a little bit frightening.
Okay, so it is substantial research. Again, I don't think Reeves is doing anything here other than sharing his good faith belief that the study is something that can be relied upon. I presume he simply lacks the training or expertise to know any better. Then we get to the core claim of the study that Reeves suggests we should rely on as a reliable model with predictive power for what we should expect from real juries in the real world deciding on real verdicts and prison sentences involving home defense use of force scenarios.
So did you know that you're more likely to be sentenced to a longer term, all other things being equal, if you use an AR-15 instead of a shotgun or a handgun or even a Mini-14?
Okay, well that's alarming. And where does this claim come from? Here Reeves references the study itself.
I've got to mention the Mini-14 because I found this study called Will It Hurt Me in Court when I was researching that most recent Mini-14 video I did a couple of weeks ago. This 2009 paper is by Dr. Glenn Meyer. And here's how it went. Jurors were selected for different mock trials. The facts were the same, except the study would change the gender of the defendants and the firearms that the defendants used in a self-defense incident to see if it made a big difference with the jury verdicts. The main question from the study was, are defendants judged more harshly if they use a more fearsome seeming weapon?
Okay, so that's the main question. And at this point in his original video, Attorney Reeves begins to dig into the study's quote-unquote findings. I'll do that as well. But first, let's go through the rest of the relevant clips from Attorney Reeves' video. So after discussing his take of the study, Attorney Reeves tells us that the main takeaway of the study is that juries convicted AR-15 armed homeowners 50% more than they did home defenders armed with a Mini-14.
Now get ready for this, because here's the main takeaway. In a straight-up comparison of everything else being the same, the juries convicted the AR-15 wielding homeowner almost 50% more frequently than a homeowner armed with a Mini-14.
Okay, well that's also alarming. And then Reeves shares that the study also informs us that an AR-15 armed home defender should expect to receive a sentence several times longer than a home defender armed with a Mini-14.
But wait, there's more, and it gets worse. On average, if the Mini-14 owner was convicted, he would be sentenced to about 2.5 years in prison by the mock jury. The AR-15 owner, 7 to 9 years in prison. So not only is it the case that someone who defends themselves with an AR-15, they're going to be more likely to get convicted than a Mini-14 owner, but they're going to go to jail for 3 to 4 times longer than the Mini-14 owner. All other things being equal, guys, I am dead serious thinking about swapping out my AR-15 in my bedroom with a Mini-14. That's crazy. Basically the same capabilities of the AR-15. I'm just as good a shot with my Mini-14 as an AR-15. So maybe I'll take a half-second longer reload time over 6 additional years in the clink.
And finally, Reeves wraps up the conclusions of his understanding of this study by noting this.
I was in absolute shock when I read these results. And it seems like they're legitimate because this study has been cited and restudied over the years.
Okay, assuming the results of this report are correct. So, is this an informed understanding of this study? Is it true that we can rely on this study as a model for how we should expect real-world juries in real trials dealing with actual home defense scenarios to distinguish between a home defender armed with an AR-15 and another armed with a Mini-14 in terms of both conviction rates and sentencing? The answer is absolutely not. Now, perhaps juries would make those kinds of distinctions, who knows? But this study certainly provides no reason to believe that would be the case, because the study is methodological garbage. Keep in mind what the study is claiming to be doing. It's claiming to be modeling through this study what would happen in the real world. More specifically, it's claiming to be modeling a home defense scenario trial so as to be predictive about what conviction rates and sentences could be expected from a real-world home defense scenario trial. The extent to which this kind of study of a model trial would be predictive of a real-world trial is obviously entirely a function of how thoroughly the model trial accurately reflects how a real-world trial would be run. If the model is an accurate reflection of a real-world trial, then it might well have good predictive value. On the other hand, if the model is a grossly inaccurate, defective reflection of a real-world trial, then it would be expected to have little, indeed maybe negative, predictive value. And this study is exactly that, a grossly inaccurate and defective reflection of a real-world trial. Now, as someone who's read a great many studies of various dynamics of use of force law, in which the methodologies are designed by people who are psychologists or social scientists, but notably who are not lawyers, a common and fatal defect is that they are simply ignorant of how the law and legal process actually works, and therefore their methodology fails to accurately model the real-world legal environment. And that's the fatal defect in this particular study. It simply fails to realistically model how the real-world legal process works, and therefore it's utterly valueless as a predictive tool for what real-world legal outcomes to expect. It's analogous to building a model of an aircraft to test in a wind tunnel, except you mount the wings on the model so the flat surfaces, rather than the leading edge, are facing into the airflow. That's not how real-world airplanes work, so your defective model airplane would have zero predictive value of a real-world airplane and how it would perform. Now, I should mention here that we are really dealing with one study, but two different reports of that study. The report that Attorney Reeves appears to be relying on is entitled, "Will It Hurt Me in Court? Weapons, Issues, and the Fears of the Legally Armed Citizen," and it was published in a publication called the American Society of Trial Consultants in 2009. And Reeves helpfully linked to this report, and I read the report. And it immediately became apparent to me that this was not an actual scientific study written to any standard of scientific rigor, but merely a kind of dumbed-down version of a scientific study for a non-science audience, specifically for lawyers and trial consultants. For example, this report lacks the methodology section one would find in any actual scientific study. Fortunately, I was able to locate the original scientific report of findings that was the basis for this study called "Will It Hurt Me in Court?" The actual scientific report of the findings is titled "Juries, Gender, and Assault Weapons," and it was published in the Journal of Applied Social Psychology also in 2009. As a scientific report, this original version of the study findings does include an actual methodology section and additional details on how the study was run. And here is where the study's defects become apparent. First, though, let me share the general design of the study and its findings, and then we can explore the study's defects. So the key question to be addressed in this study was, can weapons-related factors and gender influence jury decisions? And more specifically, as to the purpose of the study, our study may give insight into appearances-based attributions. Thus, we tested the influence of various types of weapons on simulated jury decisions. Our defendants judged more harshly if they use a more fearsome-seeming weapon. Now, the methodological design of the study was to devise a home defense scenario in which the homeowner shoots dead a threatening burglar. present that scenario to a mock jury composed of student volunteers, and then tabulate variances in the mock jury's findings of guilt and sentencing to see whether these varied with the appearance of the weapon used by the home defender. For our purposes, we're focusing here on the AR-15 versus the Mini-14 alternatives. This is the study's scenario to be considered by the mock jury. A homeowner hears a sound downstairs at night and investigates. The homeowner comes to the foot of the stairs and is armed. A burglar is discovered in the act of stealing a VCR. The homeowner challenges the individual, who responds with an obscene threat. However, no move is made toward the homeowner. At this point, the homeowner shoots and kills the intruder. This is the scenario on which the mock jury was asked to return a verdict of guilty or not guilty, as well as a sentence. I'll note up front that a major defect in this methodology was simply the composition of the two model juries. The first model jury consisted entirely of student volunteers between the ages of 18 and 21, as you might expect to get from a college or university. Body of students. In my more than 30 years of practicing criminal law, I have never seen a jury in a killing case that consisted entirely of jurors between the ages of 18 and 21. That alone makes this model jury entirely unrepresentative of a real-world jury. The second model jury supposedly had a greater variance in the age range, but also consisted of student volunteers, and the only details are provided about the ages are that they were between 16 and 47, with a median age of 26 years. And this is still entirely unrepresentative of a real-world jury. First of all, no 16-year-old would ever be seated on a real-world jury. Secondly, a median age of just 26 would be shockingly low for a killing trial, especially when the median age of U.S. adults generally is 39. If the model juries are unrepresentative of real-world juries in similar cases, it goes without saying that the decision of the model jury on conviction and sentencing would also be unrepresentative of real-world juries' decisions on conviction and sentencing. Another major defect of the study design involves the entire notion of jury sentencing altogether. Except for a small minority of 6 states, jurors have no role whatever in sentencing a convicted defendant. So all the findings of this study on the matter of sentencing are by definition utterly and completely irrelevant to the large majority of 44 states in which sentencing is done by judges, who are obviously technical legal experts, generally applying sentencing guidelines, and not by lay juries untrained in the law and free of the constraints of sentencing guidelines. For that reason, I'm going to largely discard any of this study's claims having to do with longer sentences for AR-15 armed home defenders, because the entire premise is simply not reflective of how sentencing is done in the large majority of states. Further, even in the 6 states in which juries do play a role in sentencing, and those 6 states, by the way, are Arkansas, Kentucky, Missouri, Oklahoma, Texas, where this study took place, and Virginia. Even in those states, sentencing doesn't happen, obviously, until the defendant is first found guilty. And this study's findings on rates of conviction are also inherently defective. That is, to the extent that real-world trials do not have juries set sentences, and 44 of the 50 states do not, then this study utterly fails to model or be predictive of real-world sentencing. The sentencing findings then are simply trash in terms of predictive value for this model scenario on trial in the vast majority of states. But it's worse than that, because even in the 6 states where juries do have a role in sentencing, you don't get to sentencing before you determine a verdict of guilty in the first place. And the manner in which this study models verdicts is also trash. First of all, we each have a constitutional right to a jury before our peers, and that means a fair and impartial jury that will render its verdict based solely on the relevant facts and evidence presented at trial, and based upon the law as they are instructed by the judge. In fact, every juror takes an oath to do exactly that. But often people are not aware of their biases and partiality, so the criminal justice system has devised a method to look for and identify those biases and partiality where they might exist. This process is called voir dire, literally meaning to speak the truth. You may be more familiar with the phrase jury selection. During voir dire is where the attorneys can question prospective jurors for biases and partiality. For example, whether a juror might be inclined to render a verdict of guilty based on something other than the relevant facts and evidence and other than the law as instructed by the judge. For example, whether jurors would be more inclined to convict based on the fact that the home defender used an AR-15 rather than a Mini-14. There is no basis in law to be more predisposed to guilt because of the aesthetic characteristics of the weapon, a weapon otherwise lawfully used in self-defense. So any juror that did arrive at a verdict of guilt based at all on the appearance of the rifle would be arriving at guilt based on their biases and partiality rather than on the evidence and law. Such prospective jurors would be appropriately excluded from being seated on the jury for cause. They are demonstrably incapable of carrying out their sworn duty in an unbiased and impartial way. Now let's turn to the study itself. In what manner does it replicate this vital voir dire screening process in the selection of its mock jurors so as to properly exclude any prospective jurors expressing precisely the kind of bias and partiality that this study seeks to examine? That is, a greater likelihood to convict based on the aesthetic characteristics of the weapon used in otherwise lawful self-defense. The answer is the study does nothing of the sort. The entire vital step of voir dire simply doesn't exist in this study. There is no step in this study's methodology to screen out prospective mock jurors possessing the bias of leaning towards guilt based on the impermissible basis that the weapon used in otherwise lawful self-defense had an appearance that they found off-putting. The absence of any such voir dire step in this study's methodology is a major failure in the study's claimed mission to model and be predictive of how a real-world jury would respond to the home defense scenario presented. There's yet an even bigger and rather catastrophic failure in the study's attempt to replicate real-world trials, however, and that is its utter failure to properly assign the burden of proof. Critically, in a self-defense case, the defendant, in this study scenario, the home defender, has absolutely no burden to persuade the jury of their claim of justification in killing the burglar. To the contrary, 100% of the burden of persuasion is on the prosecution to disprove the claimed justification. Even more important, the prosecution must disprove the claimed justification beyond any reasonable doubt. This means that even if the jury believes it is more likely than not that the shooting was not legally justified, that's still a verdict of not guilty, because more likely than not is not sufficient to meet the burden of beyond a reasonable doubt. An even 10% or 20% prospect that the shooting might have been justified should lead the jury to properly return a verdict of not guilty, meaning that even 80% or 90% proof against the claimed justification is not sufficient to rationally return a verdict of guilty. Now let's turn to the study. In what manner does the study inform the mock jurors that the burden of persuasion on the claimed justification is entirely on the state, and that it is the state's burden to not merely disprove self-defense, but to disprove self-defense beyond any reasonable doubt? Answer: the study does nothing of the sort. There is not a word in the study anywhere, not in the methodology or elsewhere, that so much as mentions the burden of persuasion, who bears it, or to what threshold of proof. This means that we should reasonably expect that when the mock jurors were asked to determine whether the scenario shooting of the burglar was justified, they arrived at their decision the way most of us arrive at our decisions, by a preponderance of the evidence. Do they think it was more likely than not justified? And if not, they'd vote guilty. But more likely than not is not the legal standard that a real-world jury would be instructed to apply to a real-world home defense scenario. So again, the absence of any discussion of burden of persuasion in the study's methodology is a major failure in the study's claimed mission to model and be predictive of how a real-world jury would respond to the home defense scenario presented. Would these mock jurors have been more likely to return a verdict of not guilty if they had been properly told that they were to return not guilty unless they believed the justification of self-defense had been disproved by the state beyond any reasonable doubt? It hardly seems likely they would have been more likely to arrive at a verdict of guilty if they'd been properly instructed. And believe it or not, it gets even worse. Jurors have essentially two roles they play in arriving at a verdict. The first role is to be a finder of fact. They listen to the evidence and testimony and decide what credibility and weight to assign to that evidence and testimony. Then at the end of the trial, they are instructed by the judge on the law that they are to apply to their evaluation of the evidence and testimony. This process is called jury instruction and is so obviously critical that one would think it would need mentioning. Jurors, as lay people, don't know what the specific law is to be applied in any particular trial. They don't know what the legal requirements are for the legal justification of self-defense, and they are not expected to know. Indeed, even worse, the jurors might think they know what the legal requirements are and be mistaken. Nobody would want to be convicted based on a juror's ambiguous understanding of the criminal law. So the criminal courts, the judge, have this critical step at the end of the trial in which they instruct a jury on the legal definition of the justification of self-defense, what is required to qualify a defendant under that justification, and what might exclude a defendant from that justification. It should be obvious that absent the relevant jury instruction on the justification of self-defense, the jury would not be coming to any kind of legal conclusion as to guilt at all. They'd simply be applying whatever their subjective, ambiguous understanding of self-defense law might be, however legally mistaken that understanding is. Now, let's turn to the study. In what manner does the study instruct their mock jury on the legal justification of self-defense? Answer: it does nothing of the sort. There's not a word in this study anywhere, not in the methodology or elsewhere, that so much as mentions any instruction to the mock jurors on the actual legal definition of self-defense. We literally have no idea how these mock jurors arrived at their verdicts of guilty, but we can be certain that however they did so, it was not based on the application of actual law to the facts and evidence of the scenario, as a real-world jury would do. So again, the absence of any discussion of the legal definition of self-defense in the study's methodology, no jury instruction on self-defense, is a major failure in the study's claimed mission to model and be predictive of how a real-world criminal jury would respond to the home defense scenario presented. And I'm afraid it gets still worse. The model scenario explored in this study obviously raises the possibility of a legal justification of self-defense. Although, as we've just seen, there is zero indication that these model jurors were instructed in any way on the legal definition of this justification. But critically, the legal justification of self-defense is not the only legal justification supported by the facts of this case. Indeed, it's not even the strongest legal justification. This study was performed in Texas and involved college students in Texas academic institutions. Certainly then, if any state's laws would have been instructed, and as we've seen, none were, it would be the laws of Texas. Texas is among the many states that provide for special provisions for the use of deadly force in defense of one's dwelling, precisely the scenario presented in this study. In particular, in Texas, if a homeowner, here the model defendant, encounters in his home a forcible and unlawful intruder, the law creates a legal presumption that the homeowner has a reasonable perception of an imminent deadly force threat from that intruder. This legal presumption essentially satisfies every one of the legal requirements required to justify the homeowner's use of deadly defensive force. In this model scenario, the homeowner's shooting of the burglar. This additional provision for the use of deadly force in defense of dwelling is entirely independent and in addition to the legal justification of self-defense. It's effectively an independent legal justification for the use of deadly defensive force by the homeowner in this model scenario. Now let's turn to the study. In what manner does the study instruct the jury on this legal presumption of a reasonable fear of imminent deadly force harm when a homeowner is defending his dwelling against a burglar? Answer: again, it does nothing of the sort. There is not a word in the study anywhere, not in the methodology or elsewhere, that so much as mentions this legal presumption of a reasonable fear of imminent deadly force harm when a homeowner is defending his home against a burglar. Might the mock jurors in this study have been more likely to have arrived at verdicts of not guilty had they been informed of this Texas defensive dwelling law? I mean, it hardly seems likely they would have been more likely to arrive at a verdict of guilty. So now we can infer that not only weren't these mock jurors told what the legal definition of self-defense even is, and so they had no way to apply that legal definition to the study scenario in arriving at a verdict, they also were not told of the alternative and even more favorable to the defendant legal justification of defensive dwelling. And we're still not done, because there's yet an additional justification under Texas law for the use of deadly force in this scenario, the model scenario, and that is defense of property. Texas uniquely allows for the use of deadly force in defense of even mere personal property. No other state allows this, but Texas does. In this scenario, the burglar is caught in the process of stealing a VCR at night. These facts support a legal justification for the use of deadly defensive force in defense of property, entirely independent and in addition to the legal justification of self-defense and the legal justification of defensive dwelling we've already discussed. Now again, let's turn to the study. In what manner does the study instruct the model jury on this lawful use of deadly defensive force in defense of personal property under Texas law? Answer: again, it does nothing of the sort. There is not a word in this study anywhere, not in the methodology or elsewhere, that so much as mentions this lawful use of deadly defensive force in defense of personal property under Texas law. Might the model jurors in this study have been more likely to have arrived at verdicts of not guilty had they been informed of this Texas defensive property law? Again, it hardly seems likely they would have been more likely to arrive at a verdict of guilty. So not only does the study fail to correctly model the legal justification of self-defense to this mock jury, leaving them to their own imagination whether the shooting of the burglar might be qualified as legally justified self-defense or not, the study utterly fails to so much as whisper the equally applicable and arguably more favorable to the homeowner legal justification of defense of dwelling, as well as the third legal justification of defense of property. It's important to keep in mind that even these mock jurors can rationally arrive at a higher rate of conviction for the scenario homeowner with the AR-15 than for the scenario homeowner with the Mini-14, only if there's at least some reason to arrive at a guilty verdict under any circumstances. To put it another way, if the shooting was legally justified, there is no higher rate of guilty for the AR-15 because there is no guilty at all. And this study utterly fails to model or be predictive for any of the legal defenses that would actually be raised in a real-world trial to real-world defendants, and so has no predictive value whatever. In summary, this study incorrectly presumes that it is jurors that typically determine sentences, not in 44 out of 50 states. It incorporates no voir dire or jury selection process to filter out prospective mock jurors who might be biased against the aesthetics of an AR-15 rifle and incorrectly arrive at a guilty verdict based on that. The study never informs the jury that the burden of persuasion is on the state to disprove self-defense beyond any reasonable doubt. It never instructs the mock jurors on the law of self-defense at all, and it completely fails to even mention additional legal justifications that are arguably even more favorable to the model homeowner than is self-defense. In other words, this entire study is just a dumpster fire of legally irrelevant nonsense, and it's of zero value as a model or predictor of how a real-world trial or jury would evaluate the use of force scenario presented here, this home defense against a burglar. As mentioned earlier, garbage in, garbage out. And what this study has produced is just a lot of garbage out. Finally, I would mention one more factor here, a non-legal factor that I think also confounds the findings of this 2009 study. So in 2009, there were about 400,000 AR rifles in the hands of private citizens. Currently, there are in excess of 20 million AR pattern rifles privately owned. I would suggest that the AR-15, having become by far the most common privately owned rifle in the United States, is far more likely to mitigate a reflexive fear based on the rifle's aesthetics than it is to aggravate that kind of fear. Okay, folks, before I wrap up, I want to share with you how you can join us for our 100% free Law of Self-Defense Hard to Convict webinar coming up in just a few weeks. As the title suggests, this free webinar teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. The webinar is live streamed by me, so I'm teaching it live. It's not pre-recorded, and there's plenty of opportunity for live Q&A. It is 100% free, again, but we do limit seats to allow for adequate Q&A with the attendees. So I urge you to grab your seat right now by signing up at lawofselfdefense.com/hard-to-convict. And I'll close out by reminding you all again that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.